All right. So this week, we're going to be looking at the concept of what happens when we have a pretermitted heir. Now, pretermitted is just another way of saying omitted, right? So if we have an instrument like a will or a trust, what happens if the will or trust was executed before, let's say, a person got married and got a spouse, or if a person were to get a child after the execution of the instrument. That's what we're going to be looking at here when we look at the concept of pretermitted heirs. Now, California has statutes that govern the omission of spouses and the omission of children. And even though we're reviewing this in our study of trust, this is also applicable to wills as well. So keep that in mind. Before we jump right into what a pretermitted spouse says or what the California statutes say, I like for us to review community property and quasi-community property concepts, because those are going to be essential for us to understand what the statutes say about a pretermitted spouse and a pretermitted child. So let's look at community property. As by way of review, community property is all property acquired during marriage, whether real or personal, wherever situated, regardless of which spouse acquires the property while domiciled in California. So once again, community property is all property acquired during marriage, whether that be real property or personal property, wherever that property is situated, regardless of which spouse acquires that property when the parties are domiciled here in California. So for example, if husband earns money during marriage while they are both residents of California, but keeps all his money in a separate bank account, that separate bank account or the funds in that separate bank account are still considered community property. Okay? So it doesn't matter that it's the husband that's earning the money. It doesn't matter that he keeps it in a separate bank account that he considers only his. By way of California law, specifically the laws of community property, the money is considered community property. And why is that? The reason why is because each spouse has an undivided 1/2 interest that vests immediately at the moment that the property is acquired. So each spouse has an undivided 1/2 interest that vests immediately at the moment the property is acquired. So in a sense, the reason why it's not the husband's, why the money is considered community property is because the moment he earned that money, immediately half of that money belonged to his wife. Okay, so that does not vest later on at death. It does not vest at, for example, at termination of a marriage. It vests immediately at the moment the property is acquired. Each spouse gets 1/2 interest in that particular piece of property. Now, why is that important for our studies of wills and trusts? The reason why it's important is that because each spouse gains a 1/2 interest immediately at the moment the property is acquired, that means that a spouse can only devise their portion of the community property. Okay, so essentially this limits a decedent's testamentary power to only 1/2 of the community property. Essentially what it's saying is that a person cannot give what they do not own. And in cases of community property, because they only own half of the property, they can only essentially give away half of the community property. And so that's important to bear in mind as we review these concepts, especially as it relates to the pretermitted spouse. In a related concept, we also have issues with quasi-community property. Quasi-community property is similar to community property, but it is a little bit different. So let's take a look at what quasi-community property is. Quasi-community property is all personal property wherever situated, and all California real property acquired by the decedent while domiciled elsewhere that would have been community property if domiciled in California at the time of acquisition. Now that's a lot, but it was actually very similar to our definition of community property. instead of just involving personal property and real property like community property does, quasi-community property says all personal property wherever situated and all California real property. Okay, that's because in California, community property laws are going to govern. So the key point is, where are they domiciled? If they're domiciled in a state that is not a community property state, then California treats that property as quasi-community property. So because they're domiciled elsewhere, that would be considered separate property. But if it is acquired during marriage, whereas in California it would be considered community property, at the time of death, we're going to consider it quasi-community property and treat it as though it were community property. So once again, the rule is all personal property wherever situated and all California real property acquired by the decedent while domiciled elsewhere that would have been community property at the time of acquisition. So let's give an example to understand this concept. Let's say husband buys a boat while he and his wife are living in Colorado, a separate property state. Husband and wife move to California. The boat at death is considered quasi-community property. Right? So hopefully that helps you to understand the difference between community property and quasi-community property. But if we're going to treat quasi-community property at death as though it were community property, why go through all the hassle of specifying whether a property is community property or is quasi-community property? Well, there is a key difference. And the key difference is that while living, neither spouse has an interest in the other's separate property, right? That's different than what we talked about with community property. With community property, if both parties, both spouses are domiciled in California, then that property is considered community property, and each spouse gets an immediate 1/2 interest that's vested at the moment of acquisition. That is not true for separate property. When it comes to separate property remains separate property until the one of the spouses passes, and then we're going to treat it as quasi-community property. So what does that mean? That means that the husband has no power to dispose of the wife's quasi-community property if he dies first. So let's look at an example to help us understand that. Let's say husband and wife move from Oregon, a separate property state, to California. During their time in Oregon, husband buys a car with his earnings and wife earns, let's say, $50,000. And let's assume for this example that they own no other property. And let's say that, unfortunately, they both fall ill and die in California as residents of California, but husband dies first and then the wife dies 2 weeks later. What can the husband devise in his will? Well, because the car and the $50,000 were acquired in Oregon, but during marriage, the car and the $50,000 are considered quasi-community property at death. So husband can will away the car, but he cannot will away any portion of the $50,000 that the wife earned, because in this scenario, wife is still alive when the will takes effect, as he does not die until, or she does not die until 2 weeks later. Now, if they had acquired the car and the $50,000 while living in California, then certainly the husband can will away half of the car and half of the $50,000, because the property would be considered true community property, and each person has a present undivided 1/2 interest that vests at the moment that the property is acquired. But here, since it is quasi-community property, husband does not own any interest in the wife's $50,000, and therefore he cannot will any portion of it. So I hope that helps distinguish why we go through the trouble of categorizing certain property as either community property or quasi-community property. Even though they are similar, the key difference is, especially as it relates to wills and trusts, while one of the spouses is living, they have no power to dispose of the other spouse's portion of that property. Now, with that background, let's take a look at the omitted spouse or omitted domestic partner rules here in California. This comes from Probate Code section 21610. And essentially what this code states is that if a decedent fails to provide in a testamentary instrument, for example, like a will or a revocable living trust, for his or her surviving spouse, and the decedent and surviving spouse were married after the execution of all the decedent's testamentary instruments, the omitted spouse shall receive no more than his or her intestate share. Okay, so I know that was quite a bit, so let's break it down so that we can completely understand what's going on here. Okay, so the scenario is this. We have a testamentary instrument that is executed before the spouses are married or the domestic partners form their domestic partnership. Okay, so in those cases, that's the scenario this opens up into, is that we have a testamentary instrument, example, a will or a revocable living trust. It is executed, and the person who executes it then gets married. Then the question is, what do we do with the spouse? The assumption that the law presumes is that he or she would have wanted to provide for it and did not provide for it. So the law essentially assumes that a person would want to include a spouse in his or her estate plan, and or specifically in her will or in her trust. And so the law is going to insert their spouse and going to say that, well, the decedent spouse is going to want to give the surviving spouse at least his or her intestate share. So that's how this is going to show up on an exam, and this is how it works: is that we have an instrument, or the issue spotter is going to be that we have a testamentary instrument that's executed first, and then the marriage comes later. Okay, and then we have the spouse is going to provide, the surviving spouse is going to be deemed to be provided through this pretermitted spouse statute in the probate code. Now, there are a couple of exceptions to this. Okay, so even though this is the default position, that if we have a testamentary instrument that's executed first, and then we have a marriage, then the assumption is that they would want to be provided for through this statute. However, there are a couple of exceptions, and specifically there are 4. The first exception is that there's evidence on the face of the testamentary instrument itself that the failure to provide was intentional. Okay, so we don't bring in extrinsic evidence in this particular case, but if we look at the instrument itself, if we look at the will, if we look at the revocable living trust, and we see that there's evidence that the failure to provide was intentional, then the omitted spouse will not take. Okay, so if there's something in the instrument that says that this was an intentional omission, then clearly they should not take. Also, if we have proof that the spouse was provided for by an outside transfer outside of the testamentary instrument, so outside of the will, if there is evidence of that, and based on the transfer itself, either the transfer states that this is in lieu of providing for in the instrument, or it's based on the amount of the transfer, that we can infer that the decedent intended to provide for the spouse outside of the testamentary instruments, or some other evidence. If we have evidence that the spouse, the decedent spouse, was trying to provide for the surviving spouse some other means, for example, a life insurance policy, let's say there's $1 million life insurance policy, then we may be able to infer from that the decedent tried to provide for this spouse outside of the instrument, and therefore they will not take in accordance with the omitted spouse statutes. Okay, and then, of course, if there is a prenuptial agreement or a postnuptial agreement, or any nuptial agreement where the spouse essentially waives his or her rights to the decedent's estate, that certainly is going to be another way that that tells us that the spouse is provided for, is not going to be provided for, and that this statute shouldn't apply. The last one is called the care custodian exception. So what is the care custodian exception? So let's understand what a care custodian is, and I think it'll make a lot of sense what the exception says. A care custodian is a person who provides health or social services, like, for example, administering medicine, providing assistance with hygiene, companionship, housekeeping, those kind of things, to a dependent adult, unless that person, without remuneration, had a personal relationship with the dependent adult at least 90 days before providing those services, or at least 6 months before the dependent adult's death, or before the dependent adult was admitted to hospice care. Okay, so a care custodian is a person who provides health or social services to a dependent adult, unless that person, without remuneration, had a personal relationship with the dependent adult at least 90 days before providing these services, or at least 6 months before the dependent adult's death, or before the dependent adult was admitted to hospice care. Okay, that is a care custodian. So if you have someone who's providing these kind of health or social services, for example, let's say they're helping them with the shopping and cooking, let's say the decedent is infirmed, okay, this person might qualify as a custodian unless they had a personal relationship at least 90 days before providing those service, or 6 months before the dependent adult's death, or before the dependent adult is admitted to hospice care. And it's easy to see why this is important when we look at the exception itself. The exception says that if a person is a care custodian spouse, okay, so if we have a situation where we have a person who is a care custodian and now they get married, then the issue is one of, is there undue influence? Is there fraud? Is there some kind of overcoming of this person's will, right? Because when you are, if a person is in a position needing, these kind of services, they are generally in a vulnerable class and may be taken advantage of. So the care custodian exception essentially says that if we have a care custodian and that care custodian becomes the spouse, then that person will not inherit his or her intestate share under certain conditions. And those conditions are if the marriage was commenced within 90 days of the spouse providing those services, or after the termination of those services, and the decedent died at least 6 months after the marriage commenced. Okay, so if we have that situation, whereas a spouse generally gets his or her share, or in the case of an omitted spouse, he or she would generally be deemed to have been considered pretermitted, and we would give him or her intestate share. In the case of a care custodian, if we have a care custodian situation where the former care custodian is now a spouse, then we're going to say that they should not inherit if they meet the conditions of this exception. Now, of course, this exception or this presumption can be overcome. For example, if there is clear and convincing evidence that the marriage was not the product of fraud or undue influence, then the omitted spouse can get his or her share. But unless they overcome that presumption, the presumption is that if a person who is a care custodian marries the decedent and they do so within these certain conditions, within essentially 3 months, then we're going to assume that the marriage was essentially a product of fraud and undue influence, and therefore they should not inherit because maybe they use their position to influence this omitted spouse. So the care custodian exception is essentially the exception to the exception that an omitted spouse generally can get his or her intestate share. Now, very similarly, we have a situation for children. And so in California, a person can intentionally disinherit his or her children. California does not have a statute that protects children from being unintentionally omitted from a person's will. These omission statutes, also known as pretermitted statutes, state that if a decedent fails to provide for a child born or adopted after the execution of all of the decedent's testamentary instruments, then that omitted child shall have his or her intestate share. So, California, not only, while a person can disinherit his children, if it is deemed that this child was a pretermitted child, okay? So very similar to what we have for a pretermitted spouse, where we have the execution of some kind of testamentary instrument, and then we have a child that is born or adopted after the execution of the instrument. The law is going to assume that this omission was unintentional, and that omitted child should receive his or her intestate share of the estate. So very similar to that of a spouse, and the exceptions are similar as well. So for example, if we have a child who is a omitted child, a pretermitted child, then just like we had in the spouse, if the failure to provide was intentional, and that intention appears from the face of the testamentary instrument, then the omitted child will not take. Also, if we have evidence of a transfer outside of the will or the trust, and based on either the statements of the decedent or based on the amount of the transfer or some by other evidence, it seems that the child was being provided for outside of this will or trust, then that is another exception where this statute will not apply. The child will not receive his or her intestate share. And then the other exception here, the third exception, is that where we have the decedent having one or more children, but the disposition of the estate is going to be to the parent of the child. Okay? So if we have that, then the child also does not take under the omitted children statute. Okay? So once again, very similar to first, we have three exceptions here, right? We have an intentional failure to provide for the child, and that intention appears from the face of the testamentary instrument. And we also have a provision where the child is provided for outside of that testamentary instrument. But in this third example, or this third exception, I should say, is that we have a devise, instead of to the child, we have it to the parent, where substantially all of the estate of the decedent parent is given to the parent of the omitted child. Let's take a look at examples to help us understand what that means. So let's say we have husband who writes a will devising all of his property, both community and separate property, to his wife. A couple of years after the execution of the will, husband and wife have a child. After the child's birth, husband takes out a $250,000 life insurance policy, naming the wife as the primary beneficiary. And shortly thereafter, the husband dies. In this example, the child would actually receive nothing. Why? Although the child is considered an omitted child, right? Because we have the will that was executed before the child's birth. And even though the will does not provide for the child, because the child came in into being after the will was executed, because substantially all of the estate was devised to the child's mom, which in this case is the wife, child does not receive his intestate share under this exception. Okay, so that is the third exception to the omitted child statute, that if we have a substantial transfer of all of the estate to the parent of the omitted child, whereas generally the child would be provided for, in this case, because substantially all of the estate is given to the parent of the child, the assumption is that it would be for the care for the child, and so the child would not inherit directly and would not take under this statute.